Hi everyone, this is part 2 of the video of the general jurisprudence lectures. So in the previous video I discussed about a particular aspect of Professor Leiter's response to Professor Greenberg's formulation of a standard picture on the basis of only a claim of Professor Raz that he uses the source thesis which justifies the content on the basis of which interpretative sources means that it talks about metaphysical grounding, which is a sort of a misnomer because his whole standard picture is flawed because a legal text, even if it talks about the public language of the community, can itself be altered by the same public language. So, it being said that it is a central thesis to his whole standard picture fails miserably on this ground, as how Professor Bryan has talked about. Now I have talked about certain things and I would like to clarify one thing first. I would like to clarify that Hart's description of law, because I will come to the another lecture I will take up on this nature of law series, because this is extending a lot and I need to explain, because Hart's theory was a very sociological enterprise, a descriptive analytical sociological enterprise. So his theory I gave it through an example of rules of games, but he has clarified that it is basically what the officials converge and accept them from the internal point of view is what it makes a law a legally valid law. Because rule of recognition itself provides that what the law is morally required or not, and when the officials or the practitioners when the practitioners and officials converge and accept it from an internal point of view, that rule becomes a law. So this is the basic point of Professor Hart, and this has been continuously been misinterpreted and has been utilized through grounding, whether or not legal fact grounds social facts, or whether or not a natural lawyers camp is divided, that legal norms are grounded by social facts as well as moral facts to distinguish. So, and then to say that legal facts itself is not metaphysically basic because social facts and moral facts are itself not so metaphysically basic, then why are we talking about metaphysical foundations? So Shapiro's metaphysical turn is that he uses Greenberg's idiosyncratic conception of the question of general jurisprudence, much of which is largely consequential, and telling himself to be a positivist, he adopts an anti-positivist viewpoint. So that's the kind of the misnomer with which he uses this camp, and he flouts it and he takes it to his disadvantage and he fools us. So this is what I want to say, that he is not a smart philosopher. So Shapiro explicitly frames his inquiry in the metaphysical terms popularized by Greenberg's analytical jurisprudence and examines the metaphysical foundations of law. He says that meaning the supposed metaphysical determination or grounding relations between moral facts, legal facts and social facts. Yet his reframing of this debate it renders it obscure, because legal positivists and Dworkin disagree about whether a norm can be legally valid, that is, exist as a norm in the legal system without also being morally justified in some measure. So Dworkin thinks legally valid norms must satisfy some kind of moral test. This does not mean legally valid norms have to be morally good ones, which Fuller, Simmons, which which Fuller, Simmons, which the Finnis, they were talking about making it morally good enterprise, making the legally valid norm, which was supposedly to primarily govern the conduct of the society, to make it a morally good norm. Good norm. That was not what Dawkins' enterprise was. Dawkins' enterprise was it needs to satisfy an additional moral test, but that doesn't mean that it was supposed to be a morally good one. So that is what he calls his morally justification conception as his constructive interpretation of law, and that is what it differs between the functional theory that I talked about from law as a saw and law as a hammer. Law as a knife and law as a saw, because it has distinguishable claims of how it can be used, but from a very standard viewpoint, Dworkin talks about how a constructivist interpretation would say that legal valid norms must satisfy some kind of a moral test, which doesn't necessarily mean that legal norms are morally valid good ones. Unlike positivists who deny that this is necessary that they do so, or deny that this is possible for a moral test to be a criterion for legal validity, that is why we have positivists and philosophers like John Finnis disagreeing about the central cases of law for the purpose of jurisprudential theorizing, to be identified by first figuring out what kinds of law and legal systems would generate genuine moral obligations. So Finnis affirms that there is genuine moral obligations to particular legal norms, whereas positivists deny it. That is why we have the inclusive positivist camp and the exclusive positivist camp, which I'll talk about later, and how it makes sense that the positivists don't talk about legal validity from the perspective of a moral test justifying the legal validity of a rule of recognition. What positivists are also not saying that the legal validity of a rule which is justified by a rule of recognition is a morally good one or morally requirable one. So these are all conceptions of good law, conceptions of common good, conception of good life. These are all Finnis and natural lawyers claims which are not positivist claims, and positivists have been away from this to the extent that they have gone extreme to note that there are morality or moral claims not even determining what the validity of a law or a rule of recognition should itself rest upon. That was what Raz's claim was through his source thesis. Now, I would say that this adds nothing. The whole question is what is meant by the central cases, why are they central, and how is morally relevant to specifying them to be central. None of these questions illuminates the central feature of facts, that moral facts determine legal facts, which was Finnis's main claim, which was Shapiro, which I would say Shapiro's main claim was, because he was saying from a positivist ground point, which is a misnomer, I would say so, because he is not a positivist or an anti-positivist, and I don't know what kind of a philosopher he is, because his whole book is based on a very fallacious reasoning. But that is what Finnis claims. So Shapiro is right to say that positivists and natural lawyers have different answers to the questions of what grounds authority in a legal system, although the description of the competing answers leaves much to be desired. So according to him, legal facts, for positivists, legal facts are ultimately determined by social facts alone, and claims about existence of content of a legal system must ultimately be established by referring to what people think, intend, claim, say or do. A bit later, Scott Shapiro admits one way in which this is in fact clearly false, saying that the positivist, and I quote, does not seriously mean that the law is ultimately determined by social facts alone. So he is contradicting himself in a footnote that he has added, by the way, in page number 44, if you will say. Since social facts are not among the ultimate constituents of the universe. So at one point he's saying that the positivist claims are that legal facts are determined by social facts, and on the other hand he's saying that the positivists alone cannot make this conception that legal facts are grounded by social facts, because social facts are themselves not metaphysically basic. So how can legal facts be grounded by social facts? Surprisingly, Shapiro says that he declares that these deep metaphysical questions will largely be ignored, and we should draw a methodological line at the social and moral and treat social and moral facts as though they were ultimate. Our taxonomy of legal philosophers therefore will consider those above the line positions. From the standpoint of metaphysics, this seems as a rather thin answer, because for me, if this is a reason to try to avoid metaphysical grounding claims, then why state that issue? I'll come to an interesting viewpoint. Shapiro says that I want to ask a question, okay, to Shapiro and to basically to people like Shapiro. Which positivist? Name me one positivist that says that all legal facts are ultimately determined by social facts alone. Did Hart say that? Take Shapiro's own example for the case. He says that if it is against the law to jaywalk in New York City, that this legal fact obtains in virtue of the fact that, say, the city council voted to approve a bill that set out in writing that jaywalking is prohibited within the city, and the fact that the mayor signed the bill. Yet this legal fact about jaywalking also obtains in virtue of a whole set of semantic facts that are not social facts. Although this may depend on one's view about semantic content, but most positivists are agnostic about semantic content, because they are not talking about the semantic sting of what Dawkins had, because their view is much more broad based, much more than the legal meaning that is ascribed to a particular interpretation or an interpretivist claim. Positivist claims are much more about the validity rather than a meaning which is ascribed to it. That is why the whole point, which I have highlighted in my previous part, is that whether or not a public language of the community alters the meaning of a legal text or not is ultimately to be grounded or decided upon by a rule of recognition giving validity to such norms to be decided by the public language or not, to give legal efficacy. Because if legal validity is not given, then public changes to these legal texts would remain just in paper and not be enforced. That is the whole viewpoint. So what Shapiro is saying, that this obtains by virtue of a whole set of semantic facts that are not social facts. This legal fact also obtains by virtue of some geographic facts that are not simply social facts. Can you consider that being New York City, so you might not consider simply the New York City to be a social fact. It can be our particular land masses. It can be partly separated by water, partly denominated New York City. It also obtains in virtue of biological and psychological facts about those who comprise the city council and their actions and their mental states. Giving it a metaphysical gloss does not describe everyone's position. So you can't speak for anyone else while saying that you are taking a positivist view and simply disregarding the whole nature of the positivist camp and say that you are for the positivist by giving a metaphysical gloss. You're joking with yourself, basically. Even the problem is much more worse than this. Hart acknowledges in Concept of Law chapter 9, he says that the truth of the minimum content of natural law in any society with a legal system will, as a matter of normic necessity, that is in virtue of the facts and laws about our world, including the facts and laws about human psychology as it were, use law to deal with limited resources, limited altruism, a shared vulnerability to harm and so on. Is this minimum moral content of any legal system a matter of social fact? Hart himself claims this. There is a minimum content of natural law in a legal system. How can this be social fact? Some legal philosophers do believe that legal valid norms must have a social source, like Raz, who says, and some others believe that whether a norm is legally valid depends upon a conventional practice of officials, which is what Dworkin says. So the talk of metaphysical determination relations just obscures the actual positivist thesis at the issue and commits the positivist to a thesis that is obviously false. Because conceding effectively that it is false, Shapiro drops a footnote that says that social facts are not ultimate facts. It does not help in any way. Now consider the possibility puzzle. According to Shapiro, to have the power to make laws, one must already have laws investing one with that power. The possibility puzzle arises because it appears that anybody with power to create legal norms must derive its power from some norm, while any norm that could confer such a power must itself be created by someone with the power to do so. As he rightly knows, this is a kind of a chicken egg problem. There is in fact an evolutionary solution to the chicken egg problem. The Shapiro does not mention it, which is to deny that all chicken eggs must be laid by chickens. It suffices that an evolutionary ancestor, some proto-chicken, through some random genetic mutation lays a chicken egg from which emerges a chicken. This is not that far off of the legal positivist answer. Legal power arises often enough accidentally from a non-legal customary practice, which is one of the reasons that the idea of planning, which is the centerpiece of Shapiro's alleged alternative to Hart, is irrelevant to the phenomenon we are trying to understand. So you're getting me? So basically to say that a legal power that arises from a non-legal customary practice can also be considered to a viewpoint that a legal power is determined from there. Not basically to say that a legal authority has to be first place determining a legal rule, or a legal rule has to be determining a legal authority to enter into that infinite regress. Because a proto chicken, not even a chicken which is basically genetically mutated and bringing out a chicken, would itself show that a non-customary legal practice can itself create a sort of a legal practice for officials to make laws upon. That is what Kelsen also talks about in his Grundom, that it is presupposed when few people converge to themselves to make such a law which gives privacy to all other norms in the particular legal system. That is a pure theory, or that is a science. That is not what would make it politics to say that it is dependent upon a moral obligation or to satisfy some moral test, or whether it is a morally good one, because we are entering communitarian philosophies, we are entering individualistic rights oriented philosophies which are not central to the positivist claims. This is my argument. So Shapiro frames the natural law and positivist response to the possibility puzzle as follows. Natural lawyers say legal authority must ultimately derive from some moral norm. Example, create certain political communities moral rights to determine the terms and directions of social cooperation. This sovereign right derives from the rules or principles of political morality. Positivists, by contrast, ground legal authority not in moral but in social facts. This is what he says. Note the crucial ambiguities Shapiro's face. The fundamental rules of the legal system are ultimately norms that rest purely on social fact. That involves in the rest metaphor. It rests. So rest for positivists does not mean justifies, unlike in the natural law case. Unfortunately, Shapiro's argument trades precisely on this ambiguity and leads to more serious misleading claims in his book. From Hume, we are supposed to know, according to Shapiro, that you cannot get a normative conclusion and ought from a merely descriptive premise, and is. What does this has to do with the possibility puzzle? Legal authority arises from a psychosocial fact, that is from being taken to have authority by officials. Having legal authority is not a normative fact, it is a descriptive fact about those who satisfy the relevant power conferring rules in a particular legal jurisdiction. How can this be a normative fact? Recall Shapiro's own gloss on heart. Those who wield legal authority or legal power can do so because courts and other legal officials follow rules mandating deference to their choices. So Shapiro mistakenly writes that to say X as a legal right is to draw a normative conclusion. But it need not be. It can simply be a statement of descriptive fact about the rights X has in a particular jurisdiction. This is the major error which Shapiro makes in his claim. Now I would like to talk about the final step to the Shapiro's theory, or his main objection, which I would say so, to the theory of heart, to say that that's a categorical mistake and on the basis of which he makes up his planning theory. So the most salient property of the rule of recognition is that, according to Shapiro, is that it is a rule about other rules, that is the primary rules. The rule of recognition is also a social rule. First, the rule of recognition exists, and as content it does because and only because of certain social facts. In particular, its existence and content is determined by the fact that members of a group take the internal point of view towards a behavioral regularity and use it to evaluate the validity of norms that fall within their purview. I mean, you can recall Plunkett, you can recall Toe, you can recall Kevin Toe. These are all not legal philosophers, but these are all metaphysical philosophers. I mean, they talk about legal philosophy. I don't know why they have hijacked this system in the first place. They're using this point to ground legal system on the basis of what positivists say, that they are grounding on social fact. Because rule of recognition, according to them, is a social fact. I want to clarify here. Rule of recognition is also a rule about secondary rule. It is also a duty imposing rule. It imposes duty on legal officials to apply rules that bear certain characteristics, and it is also a rule about other secondary rules, not just primary rules. That is, rules of adjudication and legislation are legally valid in virtue of meeting the rule of recognition criteria. Second, Shapiro's formulation in the quoted passage is correct, that the content of the rule of recognition is determined by the content of the social practice. That is what criteria officials converge upon and accept it from an internal point of view. Shapiro, alas, forgets his own formulation soon enough. So, At one point he is arguing that it is made up of social facts, which is not the case, because rule of recognition is a rule about primary rule as well as about secondary rule. And second, he talks about the content determined by social facts, which is where basically the internal point of view comes, and which is where Hart was right, and which is where I don't know how Shapiro forgets his own formulation. So he says this, and then in his then from his from a conventionalist, from a very from a normative viewpoint, he comes to the conclusion that descriptive premises of rule of recognition itself is not a descriptive fact, but it has a normative fact to it. I don't know how he comes up with this conclusion, because recall what he said, that saying X as a legal right, is to be drawing a normative conclusion. But it is simply about a descriptive fact about what X has the right in a particular jurisdiction. This is the main point which Shapiro misses, and which is why every legal authority is not a normative fact. It is a descriptive fact about those who satisfy the relevant power conferring rules of that particular jurisdiction, which is validated by the rule of recognition, which gives primacy to these rules, which is what Hart's point is, and which is what Shapiro misses in the second place. So surely enough, now we understand the point here. So what basically Hart presents rule of recognition as a test of legal validity, because that is all it is, if it is a criteria, but that does not mean that rule imposes a duty. This confusion, however, is important to Shapiro, because later he says, and I quote, in the legal as distinct from moral sense, the rule of recognition is self-justifying. By law, officials ought to follow the rule of recognition for the trivial reason that the rule of recognition ultimately defines what the law is. This makes no sense whatsoever. Rule of recognition is not just self-justifying legally, since it is not part of the law. That is the point. Since it is not necessarily the case, by law officials ought to follow the rule of recognition, because it is a contingent feature for officials to converge from an internal point of view to accept a rule as a primary rule or secondary rule to govern itself, whether a rule of recognition simply gives its validity or to it or not. That simply doesn't mean that the rule of recognition is part of law. Because if they believe they ought to follow it, then there is a legal system ceteris paribus. This is the crux of Hart's view. The central argumentative move of Shapiro's criticism of Hart's account of rule of recognition is that Hart tries to demystify the creation of social rules by reducing them to social practices. In other words, social practices generates rules because these rules are nothing but social practices. A bit later, Shapiro claims that social rules cannot be reduced to social practices because rules and practices belong to different metaphysical categories. Rules are abstract objects and practice, on the other hand, are concrete objects. This is his argument. So the point which I am trying to make is the rule of recognition is not self-justifying legally. It is what basically it is distinct, because an official ought to think to follow a rule of recognition for the trivial sense that the rule of recognition ultimately defines what the law is. This is the trivial reason for it. They have to believe that they ought to follow it, and then there is a legal system. Just because you say that the law is determinative of a social rule and constitutive of social practices, and social rules are itself an abstract object, so a rule is an abstract object, and therefore it is distinguishable from a social practice which is a concrete event. They take place within the natural world and causally interact with other physical events, so one cannot be reduced to one another, is what Shapiro's basic point is. So therefore Hart, if I may clarify, if Professor Leiter has also clarified, doesn't talk about reductive analysis of rules at all, because he is not going into the ultimate constitutive nature of what is a social practice or a social rule. He simply says that a rule of recognition gives for a trivial reason as to what the law is, and law officials ought to follow it on the basis of internal point of view, and they take the determinants of these content of law which is basically the ultimate constituents of universe, which these metaphysical theorists claim, like Kevin Tope, Plunkett, and Shapiro, whoever, like Mark Greenberg, whoever all these philosophers are, and these are taken for granted because the main questions of general jurisprudence is not these issues. What is necessary for heart is that there should be a critical reflective attitude towards certain patterns of behavior as a common standard, and that this should display in criticism, including self-criticism, demands for conformity, and an acknowledgement that such criticism and demands is justified, all of which find their characteristic expressions in the normative terminology of ought, must, should, right, and wrong. It is a critical reflective attitude of certain behaviors is what is necessary, we have to point out. So if you are smoking in public, it is a critical reflective attitude of the people towards your habit of smoking in public, to make sure that it has to converge to a system of internal point of view, which is to recognize that if you smoke in public, then you ought to be beaten up or you ought to be prosecuted by law. It is what the internal point of view from a critical reflective attitude provides for. Hart here describes the behavioral evidence that people accept a rule from an internal point of view. He does not offer an analysis of what a rule is here or elsewhere. Rule functions as a kind of a theoretical primitive in his account of rule of law. So Shapiro's category-mistic objection to Hart is also wrong, for which he comes to his theory that law has anything to do with planning fails there, because his objection to Hart is itself weak. He is simply saying that Hart is simply doing a reductive analysis of rules to come to a conclusion that a critical reflective attitude of certain patterns of behavior as a common standard is necessary to display itself in criticism and demands for conformity, is why the characteristic expression of normative terminologies comes in the second place. So the critical and reflective attitude comes first, then on the basis of which this behavioral evidence that the people accepts a rule is from an internal point of view. It does not offer what a rule is supposed to be. Whereas what Shapiro is claiming, that Hart has a reductive analysis of rules of law that is constituted of rules which are of social rules, and these social rules are itself not metaphysically basic, and they are grounded on a social practice which officials converge on, which is true on the same hand. But his conclusion that rules and practices are distinguishable from each other, because one talks about concrete event which is practice and the other talks about abstract event which is rules, are simply not the point of general jurisprudence that Hart has been talking about. Instead, Hart has been identifying key weaknesses in Austin and Jeremy Bentham's views about law. They omitted the idea of a rule, relying instead on the ideas of sanctions, sovereignty, and commands. So Hart himself has no further reductive analysis of a rule. It functions effectively as a theoretical primitive notion in his jurisprudential theory. That is the point. Hart, by common consensus now, was correct that you cannot understand the phenomenon of law without reference to the idea of rule and its surrogates, which are principles and standards which Dworkin comes up with and eschews Kelsenian point of view of pure theory of law. That the idea that law consists of rules of varying types certainly has ordinary language and legal common sense on its side. The idea that law consists of plans does not. The basic reason Shapiro alleges the idea of planning is relevant to jurisprudence is because Hart made this category mistake, that he believes that law does not consist of rules because rules are itself not metaphysically basic, so we should do planning. Wow. And I don't want to get into this rabbit hole because Leslie Green has pointed out a very funny joke about Shapiro's planning theory, and it is worth recounting here. So let's take a step-by-step process formulation of what you need to do when you plan about plan to solve a problem of murder. So let's say A, we have a problem with murder around here, we need to do something about it. So B, what we have to do? So there's Shapiro who comes up as a jurist, says yes, let's make a plan. And then says, hey, the person like me, you say, so great idea, what's the plan? The plan is what Shapiro says, don't murder. I think this would rest particularly about Shapiro's planning theory, and I don't want to spend his theory into my jurisprudence lectures, which I'm going to deal with, because this video and the part before it has strictly claimed and circumscribed the position of positivists from where they stand on, from Greenberg's theory of standard picture of his formulation, from Raz's abstract content based point of view to his own viewpoint of a standard picture, to Shapiro's claims that metaphysical basic things we need to talk about rules and not hearts, or heart is not simply talking about reductive analysis, thereby making a categorical mistake. So the real mischief, and I would end this video with saying that the real mischief of Shapiro's approach has less to do with the mistakes catalogued above, that is wholesale adoption of Greenberg's new metaphysical framings of the supposed questions of general jurisprudence in terms of determination relations. No one, however, prior to 2004 thought the central question of jurisprudence concerns the metaphysical determinants or groundings of the contents of law, of how facts make law. That was simply not the question. That was missing. Many people after 2004 also should not be questioning how facts make law and how there must be metaphysical grounding. Because if you need to understand, jurisprudence needs to be purged if one wants to understand what law is and how law is, and especially how courts really operate, because that's what the general jurisprudence task is, and that's what the central issue is about what the law is, what the law should tackle, and how courts should really operate. Because there is legal realist position, there is the positivist position, there is the rule validity position of whether or not this rule is typically valid or not. We talk about particular jurisprudence, or whether or not a particular law is applicable to a particular jurisdiction or through a legal text or not. We need to be arguing about that rather than making arguments about metaphysical conditions, about how facts make up law, or how metaphysical grounding should make up law, or how Greenberg or how Shapiro or how Plunkett or how Toe comes up with their own philosophical ideas for other metaphysical philosophers to simply hijack this legal philosophy field and to simply get their PhD degrees and their research academic prizes and fellowships in order to make up these claims. These are all hypocritical and should be avoided, and I hope through these videos, through these two-parted videos, I have made you understand what my strictly the misnomer with which these positivists, who are, I would not call them positivists, for which an entire branch of anti-positivists has come out with the norms of eliminatism and what not, how morality makes up law, how legal facts make up moral facts, how moral facts are legal facts, all these misnomers as pointers. So I want to simply distinguish myself from these camps and not talk about it, and strictly limit myself to general jurisprudence lectures, because that is my task, to educate you all on these general jurisprudence lectures. I hope you like this video. I will come up with the next video soon, and I will be talking about how whether purely descriptive laws can be considered theories of law, and also the idea of legal system from Professor Ravanos and Professor Raz's ideas. And let's see how this nature of law and how this whole jurisprudence series continues. So till then, happy reading. Bye bye.